हेलो। 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 हेलो।
Yes, hello, good afternoon.
गुड आफ्टरनून सर।
Oh, good afternoon, sir.
हाँ, am I audible to you?
Yes, sir, you are audible.
Okay, okay, fine, fine.
Hello, court master, can we begin?
Yes, Your Lordship.
There's an echo.
Everyone, please switch on your cameras.
Court master, there is an echo on your end.
Everyone, please switch on your cameras. Everyone join in with the team code's name. Before starting with the competition, we will have roll call of all the participants present in the courtroom. You are requested to respond yes when I call out your names. TC15, speaker 1.
Yes.
TC15, speaker 2.
Yes.
TC15, researcher.
Yes.
35, speaker 1.
Yes.
35, speaker 2.
Present.
TC35, researcher.
Present.
A very good afternoon to our honorable judges and participants. It's my pleasure to welcome you all to the first avant-garde moot court competition organized by ICFA Law School, Dehradun. With permission of your lordship, I would like to enlighten participants of both the teams with the rules and regulations of this court. Thank you, your lordship. First of all, participants must ensure they have wired headphones connected to their laptops during the oral pleading. Participants are not allowed to leave the courtrooms until permitted. Participants are requested to keep the video on throughout the session. Participants do have to ensure they have strong and stable internet connection. Relaxation of only 2 minutes will be provided in case of any connectivity issue or any technical glitch. It's upon the discretion of the judges to decide whether they want to deduct any marks on this account or not. The card will be shown when last 5, 2, and 1 minute will be left so that the participants can have the track of the time. If the speaker fails to see the plug card, only the participants will be responsible for the same and no extra time will be given on that account. Extra time will be granted by the judges on their sole discretion. As well as participants are not allowed to speak, make any gestures during the oral pleading of the other participant. The participants are also requested to maintain the decorum once they enter the courtroom. Simultaneously, no communication is allowed between the participants of the opposite teams, and you are requested not to reveal your identity during the competition. Each team is allotted 25 minutes of speaking time, and 15 minutes per speaker is the maximum time, and rest 5 minutes will be reserved for the rebuttals and sub-rebuttals. Now, I would like to ask TC15, how would you like to bifurcate your timing among your speakers?
8 minutes for speaker 1, 12 minutes for speaker 2, and 5 minutes for rebuttal.
Okay. Now, I would like to ask TC35, how would they bifurcate their time?
Speaker 1 will take 14 minutes. Speaker 2 will take 8 minutes, and rest of the time will be reserved for rebuttals.
Now, if the teams are ready and your lordship permits, the court shall start.
Please start.
The court is in session.
May it please this honorable court. This is counsel appearing on behalf of the petitioner in the case of Star Consultancy Services versus Loki. If it would be of no inconvenience to your ladyship, may I please refer to the bench jointly as your lordship.
Yes.
Please do.
Much obliged. Now we'd like to state the jurisdiction. Statement of jurisdiction. The respondent opposes the maintainability of the instant public interest litigation under Article 226 of the Constitution of Alcatraz. The respondent seeks liberty to raise preliminary objection regarding maintainability of the petition. If your lordship may...
Miss Counsel, just a minute. You are here petitioner or appellant?
Petitioner, your lordship.
Then why you have mentioned in your memorial that memorial submitted on behalf of appellant? This is my first question. Second question, why in your line number 2 of a statement of jurisdiction, you mentioned the respondent seeks liberty to raise preliminary. You are not respondent, I guess. Are you respondent?
No, your lordship.
Then why you have mentioned it in your statement of jurisdiction, seeking liberty to raise preliminary objection regarding maintainability of petition? You are not appearing for respondent. Then why your statement of jurisdiction is related with respondent? And how 226 is relevant to your case?
Indeed, your lordship.
You are reading from the memorial of a respondent while you are appearing as appellant. This is the gross error, I guess.
Sir, I'm appearing on the behalf of the petitioner. Sir,
Petitioner
when we talk about appellant.
Decide petitioner or appellant. So this is not an appeal? This is not an appeal?
No, your lordship.
Proceed.
May I proceed?
Proceed.
Much obliged. If the lordship permits, may I please state the fact of the case in hand?
Proceed.
Please.
Much obliged. Asgard is a small, developing and huge youth population democratic country situated in Southeast Asia, where the industrial and service sector is at boom. So it makes an attractive place for the employers. There's a social media platform called HiredIn, which allows the people to create profile for employment. A pandemic hit the country in March 2020.
Miss Counsel, you are reading from your submission, each and every word. Better summarize it than wasting the court's time. We have your submission. If you have drafted your statement of fact properly or in your own way, please present it. Otherwise, you may skip it.
Much obliged. So, my lordship, may I continue with the issues?
Yes.
Issue 1, 2, and 3. I will be dealing with the first issue and my co-counsel will be arguing with the second and third issue. Issue 1. Whether the case is maintainable or not. It is submitted that the case is maintainable before the High Court of Alcatraz under Clause 12 of offer letter that in case of any legal dispute arising between the parties, the offerer star consultancy services and the offeree, the candidate accepting this offer letter, the jurisdiction of High Court of Alcatraz will prevail. Under Article 226 of the Constitution of India, we are seeking remedy for the violation of legal right of the company. Since there was an active concealment on the respondent's behalf of his actual age and knowledge of the fact that he was a minor, resulting into fraud and entering into a contract. Also, according to the statement of jurisdiction of the respondent, it states that the respondent humbly accepts the jurisdiction of the Honorable High Court under exclusive jurisdiction clause. The High Court having regard to the fact,
this is not rebuttal right now. So kindly don't mention respondent. Technically, it would be wrong.
Certainly, your lordship.
And you have not mentioned even a single case in your issue number 1. In point number A, B. What is wrong? Why you are not mentioning supportive authorities? Yes.
May I proceed further?
Okay, proceed.
The High Court, having regard of the fact of the case, has a discretion to enter a writ petition. The company acts in accordance with offer letter, Annexure 2, earlier published, which means under any breach of contract as mentioned in clause 11, contract shall be terminated and legal action will be taken. Yes, yes, your ladyship.
Writ you have filed this petition?
Your ladyship, we are here seeking remedies for the violation of legal rights of the company.
But we have 5 writs, right?
Yes, your, yes,
So
your
under
ladyship.
which writ you have filed your petition? Okay, proceed further.
Legal rights. Much obliged. The offer letter should not be accepted by any minor as per the Guard Contract Act 1872 mentioned under clause 27, but in contrary, offer letter is accepted by minor. Under clause 35(1) of offer letter, it is stated that offer letter should be clearly read before accepting, but respondent read it hurriedly, for which company shouldn't be held liable for loss suffered. It was a mere negligence on part of respondent.
If I may continue from where my co-counsel left, I would be dealing with the issues 3 and 4 with the permission of the Lordship.
No, first establish that why you doubt maintainability. Why you have the problem? Why you have drafted this issue that this is maintainable or not? Don't you have confidence that this case is maintainable itself?
Yes, your lordship, this case is maintainable.
No. Why you have made this issue, and you have made the issue case? What do you mean by the term case when you draft it in your issues, statement of issues? What is the case? We don't know about your issue. See, just read out your issue once again, which you have referred.
Whether the case is maintainable or not.
What case? Which case? Which situation are you talking about? Are you talking about capacity of minor to enter into contract, or what you are talking about? I mean, there should be something in the issue that should be indicative.
Your lordship, we will be talking about the capacity of minor to enter into a contract later. On further issue.
Is not self-explanatory. So what you are dealing with is a complete case. Okay. And are you having any doubt on maintainability? If not, why you have mentioned it in the issue itself at the first place? Okay, hand over to your co-counsel.
Much obliged.
If I may continue from where my co-counsel left, I would be dealing with the issues 3 and 4 with the permission of your Lordship.
Yes.
Much obliged. Issue 2, whether the petitioner is competent to enter into contract or not. Yes, the petitioner is competent to enter into contract in accordance to section 11 of Indian Contract Act 1872.
You have written plaintiff. You have not written petitioner. Is there a difference between petitioner and plaintiff?
Yes, your Lordship. There's a difference. Yes, your Lordship. There's a difference between plaintiff and petitioner.
Then why you are saying petitioner again and again? You have written plaintiff. So stick with that.
Your Lordship, when we talk about petitioner, when we talk about plaintiff is the one who seeks remedy in a civil action, whereas the petitioner is the one who invokes the help of a court to redress his grievances. For example, an individual can be a petitioner and file a petition.
Don't read it out. I know that you don't know about it. You are just reading it out. Point is that, are you plaintiff or petitioner right now?
Right now, I'm petitioner, your Lordship.
But in your submission, it is plaintiff. You cannot go out of your submission. This is the rule.
Your Lordship, when it comes to the court, it becomes the petitioner.
But why you are submitting plaintiff? That is also comes to the court, your submission.
Yes, your Lordship.
Then?
I'm addressing myself as the petitioner, your Lordship.
So accept that you have done error in your submission because you have mentioned plaintiff.
No, your Lordship, I am addressing myself as the petitioner.
You are addressing yourself as petitioner, but your submission is of plaintiff. This memorial is available to all of us judges. Why you are lying?
Okay, counsel, put up your case. What do you have to say?
Yes, proceed.
Yes, your Ladyship. Yes, the petitioner is competent to enter into contract in accordance to Section 11 of Indian Contract Act 1872, which defines age of majority, person of sound mind, and disqualified person to enter into a contract, according to which petitioner is competent to enter into a contract. An individual who is competent to contract can become a partner in the partnership firm. For the purpose of entering into a contract, a person is said to be of sound mind if he is capable of understanding the contract and being able to access its effect upon his interest. If a person is usually of unsound mind, it is important that while framing the contract, he should be in sound mind. Upon a contract may be made by a person of an unsound mind is void. The
Ms.
reason for
Counsel?
disqualification, yes, your ladyship,
Counsel, what is the age of majority?
above 18 years.
Above 18 years. And what is the age for contract?
18 years and above.
So here your issue is whether this person is competent to enter into a contract.
Yes,
And
your
you said
ladyship.
yes, he is competent to enter into a contract.
Yes, your ladyship. I'm talking about the company as a whole.
And what about the minor? Is he competent to contract?
No, your ladyship. As per the proposition, it is clearly mentioned that the minor is of 17 years, 11 months, and 10 days old. Therefore, he is not competent to contract.
Okay. Proceed.
The reasons for disqualification can include political status, legal status, etc. Some such persons are sovereigns and ambassadors, alien, enemy, convicts, insolvents, etc. If your lordship is satisfied with the second issue, may I move on to the next issue?
Ms. Counsel, I have the objection. Have you given any evidence with reference to your issue number 2?
Yes, your lordship. In section 11, it is clearly stated that the person needs to be of sound mind, and a company is totally of sound mind since they are disclosing the two issues, since they are disclosing the clauses clearly well, what is need to be stated and what should be not, and they are not disqualified by the Indian Contract Act. And also, they are not sovereigns, they are not ambassadors, they are not enemies, they are not alien, they are not convicts, and also they are not insolvents. Therefore, they are competent to contract.
But what about the age? You stated that your client age is 17 years, 11 months, and 10 days.
No, your lordship, my client is actually company, and their age is above 18 years, 18 years and above.
Yes, Ms. Counsel, why are you putting the question regarding the companies? There is no any question regarding the companies because company is competent to make a contract. You should not put here. There is
Your
no
lordship,
any issue regarding the company. It's a juristic person. It's competent to make a contract. Now the
Your
question is regarding the second party. Second party who is not competent to make a contract. It means there was no any contract. It was a wide avenue issue. Okay, am I right?
yes, your lordship, but it
So
is
how
also.
you are saying that there was a contract and should get the benefit of the contract and you should get the compensation?
Yes, your lordship, but when we talk about the competency of one party, we should also talk about the competency of the other party. It is totally justifiable to talk about the competency
Where it's
of
written,
both
where
the
it's
parties.
written that it's justifiable regarding the other parties. Is it written somewhere?
Can you please repeat
Refer
your
the
question, your
case law.
lordship?
Is it said in any case law regarding the other party's competency? That one party is competent and other party is not competent, so there could be a valid contract between the parties.
Section 11 clearly states that both the parties need to be competent in order to enter into a
Yes,
contract.
that's why I'm saying both the party need to be competent, but the other party is not competent, no? Second party, Mr.
Yes, your
Loki,
lordship, when we
who
question
is a
the,
minor. So it
yes, your
means there was
lordship,
no any contract between company and the minor.
yes, your lordship, I'm just trying to say that when we question the competency of minor, we should also try to clarify that the company was also
In that
competent,
situation,
so
we
that the
can't say
company
that
is not.
contract is basically established there between the parties.
Yes, sir. By your lordship, by saying yes that my company is competent to contract, I'm establishing the fact that yes, the contract that was entered by my company is totally valid.
But this contract is not a valid contract. It's a wide avenue issue.
It became void when the company came to know that the client or the employee was minor. Unless and until before that, the contract was valid. It was the fraud done on the behalf of the minor itself.
Ms. Counsel, there was only one contract, right, between the two parties. You cannot say from our side contract was valid and from their side contract is invalid. Contract is one, and it should be either valid or void.
Your ladyship, there was contract that was valid until the company got to know about the age of minor. But when the company got to know that the age of the employer
you
was
answered this question.
Sir, I'm
You
sorry,
answered
sir,
this question,
to
Miss
interrupt.
Counsel. Miss Counsel,
Lordship.
you answered this question that your status is not contested anywhere. Point number one. And also in issue number one, it was not contested that it is maintainable or not. Even in this issue number two, it is not contested that you are capable or not. Why you are self-justifying your position? The actual issue is about minor, about the respondent.
No, Your Lordship, I'm just trying to say that when we talk about the competency, the section 11 clearly states that competency should be from both the sides.
Then, in point number B, if you read that you have completely copied and pasted the disqualification, the political status, legal status, sovereign, ambassador, which was not even relevant to your question. Why you have done it?
I'm just trying to give some instances that these are the person who are disqualified, and company does not fall in these such situations.
Well, no question from my side.
Okay, Ms. Counsel. Whether minor fabricated any document with respect to age or in hiding or anything he has done to fabricate any document in order to come into this contract?
No, Your Ladyship. No, Your Ladyship. Actually, what happened that on when there was asking from some sort of documents for the verification about his age, for the total verification about his age on 25th January 2021 and 15th February on 2021, when the company got to know that he was a minor, then they typed and then they sued
that
him.
means minor has given all the documents when he entered into a contract. It was the fault on the part of company that they figured out late.
No, Your Lordship, earlier, there was the proposition that earlier the documents were earlier asked.
Okay. So,
By
No,
the
Ms.
side of
Counsel,
the
it's also a
company.
duty of the company to put it in front of the minor, because you have releasing 2 or 3 remuneration. Am I right? In 1 or 2, 3
Yes, Your
installments, you have
Lordship.
already paid to the minor.
They
Before
totally
paying any
mentioned.
remuneration
They totally
or
mentioned.
before engaging the minor into certain works, relevant works, you should inquire about the documents also.
They totally mentioned about this in the clause 27 of the Annexure 2, that it should not be accepted by the minor. They mentioned about this, clearly stated. So it's
What
totally.
about your due
It means you are
diligence?
just going to impose the duty upon the minor. What's about the duties of the company?
Due diligence.
The company was the third largest, and it has total about 2,500.
You have already mentioned in your fact that third largest company with so many resources, you have a manpower, so you should do the verification before releasing the any remuneration or before engaging the minor into the relevant works.
Your Lordship, it is the third largest software developing country in the world, and of the situation of the pandemic in the country, handling 2,500 applications, considering negligence on the part of the company is not acceptable, as later every second person can claim of not reading the letter for which so cannot be held liable for loss.
Okay, counsel, if it was a minor, the contract was signed and the minor has already performed his task, then what will be the issues? Do you have any case laws to show that it will not be binding on part of the company?
Can you repeat your question, Your Ladyship, please?
Since the minor has already got into contract and you did not at the initial stage address the question of minority, and this person has already performed, so the contract as it stands against you must be performed. Do you have any case law to suggest otherwise?
Yes, Your Ladyship, I have a case law about it. That is Leslie versus Shell case law, and I'm going to state that case law for you. It totally says it was in that case. Court explained the objective of doctrine of restitution to restore the ill-gotten gains and not to enforce the contract. Actually, in that case, defendant misrepresented his age and secured 2 loans of $200 When sued by the plaintiff for $475, Ford held that money could not be recovered as if repayment was allowed. It would amount to enforce the contract to repay the loan, which is not possible. So they were told to restore the ill-gotten gains, whatever the minor took.
Okay, but in this case, there was no fraud done by the this minor, as he had, you said, submitted his documents.
No,
So
Your
there was
Ladyship.
no fraud committed on his part.
Under Section 17 of Indian Contract Act, fraud is stated, which says that there was active concealment on part of the minor about his age. Since knowing that he was a minor, he tried to hide his age, and also he was totally not having knowledge of his age. So there was fraud done on the part of the minor.
But you have stated that he submitted his documents relating to age, so he has not done any fraud.
No, Your Ladyship, he submitted your documents only after when it was asked, that is after doing all the works, that was asked on 25th January, and the company received the documents on 15th February of 2021, and that day only they came to know that the employee who was employed, that was minor, and then they tried to sue him in the court.
No, so you should have taken whatever information you needed to ensure that the contracts which you are signing with other parties, they are valid contracts. Should you not have taken that information beforehand?
At the time of acceptance of the offer, he was a minor. And it was clearly stated in clause 27 of the Annexure 2 that it should be read that the minor should not accept it. So if the minor was prudent enough to understand all these things, then he should have understood all these things and not entered into a contract. And clause 11 of the Annexure 2 clearly states that if anyone entered into a contract and tries to breach the contract, then some legal actions will be taken against him or her. And so as done by the company.
Okay, carry on.
Much obliged.
Ms. Counsel, do you know that ignorance of law is no excuse?
Yes, Your Lord. Yes, Your Ladyship.
So
that is what is done by. Yes, Your Ladyship. I would like to state that ignoratia juris non executus, that is, ignorance of law is no excuse. That is totally done on the part of the minor. Since deceiving the company and hence the minor is wasting the time of the court, respondent ignored the laws that the minor cannot enter into contract, and therefore he tried to ignore the law.
And
did fraud.
The company also ignored the same fact, right?
Under standard form of contract, the company can form the rules and regulations on their own, and if the second party who is accepting all the rules and regulations, that means they are giving consent about all the rules and regulations, and on their giving consent, they are trying to entering into contract. It was a mere invitation to offer on the part of the company, and by accepting this, it was a mere invitation to offer on the part of the company demanding an offer, and by submitting the application on the part of the minor, they tried to give the offer to the company, and the company accepted the offer, and hence it became a contract. And by minor, when the company came to know that the employee was a minor, it turned into breach of contract, and hence they sued the minor for breach of contract and demanding compensation of rupees 5 lakhs.
Counsel, the point is that no matter you say that the agreement is valid or the contract is valid, the moment even if you don't find out that the other party is minor or not, it still stands void ab initio. The legal status never changes. Do you understand this? That yes, even if he was minor, the contract was void ab initio. The legal status never changes. Then how come you can validify this agreement? How can you give a validity to this contract?
Yes, Your Lordship, but if decision will be given in the favor of minor, then many such minors will come up hiding of the actual age, deceiving the company, and hence wasting the time of the court. Since many minors
was never valid. Contract was never valid. It was always void ab initio.
Hence, they were totally, he took even 5,000 money of the company, took the experience, And they also wasted the
Doesn't
time
make
of the
the contract
company.
valid. It doesn't make the contract valid.
But he took the money of the company.
It doesn't make the contract valid anyways.
Yes,
It
Your
is
Lordship. That's
an issue. But you are stating for last 5 minutes that it is valid. Yes, next issue.
much obliged. Issue 3, whether the petitioner would get compensation or not. Clause 27 of the Annexure 2. Under Clause 27, it is mentioned that offer letters should not be accepted by minor, but the respondent was minor as on 7/11/2020, having age of 17 years, 11th month and 10 days old. Date of birth as per the documentation is 27 November 2002. 7/11/2020 was the date of acceptance of the offer letter sent by the company, and on the same date, minor accepted the offer letter via email. That was the suggested mode of acceptance. Clause 11 of the Annexure 2. Clause 11 mentioned that the candidate should maintain the confidentiality throughout the tenure of the contract, and in case of any breach of contract shall be terminated immediately with legal consequences. Since the defendant was minor, this led to breach of contract, and hence legal actions were brought against the respondent. The petitioner would get the compensation under Section 65, which clearly states
The
that when
problem is that you are mentioning what should be mentioned in prayer. You are mentioning that you should get 5 lakh. It should be in part of your prayer, not part of your argument here.
I'm mentioning the sections and explaining about it as well, Your Lordship.
5 lakh rupees, the point which you have mentioned, it is the part of the prayer. It is not the part of the argument.
I just mentioned the word your compensation, Your Lordship.
Should get demanded compensation. What is this?
Yes, whatever the compensation is demanded from the company.
That should be part of prayer, not part of argument. Don't be stubborn on the technical errors which you have committed.
Yes, Your Lordship.
Proceed to your prayer, whatever it is, if you are in.
I have some, Your Lordship, I have some cases to deal with. May I proceed with it?
So counsel, I just have one question for you. You are saying that you want to have 5 lakh paid as the compensation. So how have you calculated this amount of 5 lakh? What formula have you applied, or how did you come to this amount?
Your Lordship, since the advertisement was done and it was published everywhere, and about 2,500 applications were received from everywhere around the world, since it is a worldwide company running around the world. So a number of employees must have been there. So the salary must have been paid to each and every employee. So resulting amount must have been.
So this is upon estimation, right? This is
Yes, Your
not
Lordship.
calculated according to some set formula. So this could have been 3 lakhs, 2 lakhs, 1 lakhs, maybe
Video
more than 5
conferencing.
lakhs.
Yes, Your Lordship. Video conferencing was also done. Applications were accepted. Advertisement was done in the newspaper. Then it may be in the maybe in the magazines also, maybe on the televisions
And you
also.
are
So you're
not
taking
mentioning that you get
everything
info.
from that person only that you have conducted, the advertisement part, everything. So the minor has to pay.
Yes, Your Lordship. Yes, Your Ladyship, because it was a great loss to the company.
In how it's a great loss to the company? He has done the work.
He has done the work, but he has violated the clause that they stated. So it tried to diminish the reputation of the company in the world as a whole.
That is not part of your argument. And secondly, you are not arguing for litigation cost also. You're not asking that.
Your Lordship, they spended the money.
Miss Counsel,
Yes, Your Lordship.
there is a query regarding the amount which you have in a pay 5 lakhs rupees. Why you should not put in the contract that if anyone is going to commit any fraud, so much amount should be, because in the contract it's based upon the liquidated damages. It's not on the unliquidated damages. And you are just claiming all the advertisement and all the amounts from the one person, Mr. Loki. It's not too much justiciable. It means it should not
Your
be
Lord,
done in this
Your
depth.
Lordship, Your Lordship, the thing that the employee was minor came to know, it was unrevealed after the everything was done, after the appointment was done. So if he earlier came to know that the employee was minor, he could have appointed anyone else. So as a result of which the advertisement went in waste. So a lot of money that he spent was in garbage only for him. So he demanded the compensation of 5 lakhs.
With this
For the
advertisement,
employment.
only one person was appointed, or other employees were also appointed, of course.
As he was a good tech enthusiast and a student as well. So
Other
his
students also appointed.
his employment was a great pleasure for them.
Okay.
But Ms. Counsel, my question is that documents already submitted to the company, then is it not the duty of the company to verify the document before selecting the person?
Your Lordship, document were asked to be submitted on 25th January. That was done after the appointment of the minor, and that was verified on 15th Feb. And after that, everything work was done, whatever the review report was to be submitted by the minor. And when they came to know, they tried to sue the minor in the court of Alcatraz under clause 12.
Come to your prayer.
Yes, Your Lordship.
Sorry to interrupt TC15, but TC35, please switch on your camera. You may continue now.
Wherefore, in the lights of issue raised, arguments advanced, and authorities cited, it is most humbly prayed before this honorable court that it may be pleased to declare, first, compensation amount of 5 lakh rupees to the petitioner; second, hold the respondent liable for breach of contract and fraud, and pass any order or orders as this honorable court may deem fit and proper in the circumstances of the given case, and thus render justice. And for this act of kindness and justice, the appellant shall be duty bound and forever paid. If may be of no further note or further assistance to this court, counsel would like to rest the case. Much obliged and most grateful for the time and patience of this honorable bench.
Yes, to TC35.
Greetings to the honorable bench. If it pleases your ladyship and your lordship, the council would like to address the bench as your lordship. Much obliged. May it please this honorable court, this is the council appearing on behalf of the respondent in the case Star Consultancy Services and Loki. If the honorable bench is aware with the facts of the case, the council would like
Have you chosen yourself to be respondent because your opposite party appears to be petitioner? So shouldn't you be defendant?
Certainly not, your lordship.
Why?
Your lordship, since the case is in the High Court, and the petitioner is filing it under Article 226. So if it's the petitioner and we are responding to their writ, so we are the respondent.
Good.
Much obliged, your lordship.
Do you object to jurisdiction?
Pardon, your lordship. Would you
Do
please?
you have any objection to the jurisdiction?
Indeed, your lordship, it will be covered in the rebuttal round. I would certainly question
whether you agree that jurisdiction is correct to 226 or not.
No, your lordship. The council
So
won't
please
agree.
give your argument. Please give your argument. Why?
Indeed, your lordship, the writ petition is filed if certainly a fundamental right is being violated, and it is always filed against a state. Here, the respondent Loki is not a state. The petitioner failed to prove under which writ they are filing. It is only the mandamus against which you can file, against which if a private individual is there, you can file a case. And certainly not, I would object the jurisdiction as applied by the petitioner, since there is no infringement of any fundamental right of the company.
So counsel, to which court should the petitioners have initially gone? What is your take on that? If you are saying that, they shouldn't have approached the High Court since this is not a case which is fit for writ, then which is the other court, or, to which court they should have originally gone, according to you?
Indeed, your lordship, if the petitioner had this issue, they would have approached the district court first. Since the district court have this jurisdiction that they can deal with the case up to 15 lakh rupees, without wasting their one of the remedies, the petitioner would have first gone to the district court.
All right. Please proceed.
Much obliged, Your Lordship. If you permit, I would like to proceed with issue 1.
Yes.
Your Lordship, issue 1 deals whether the contract between Star Consultancy Services and Loki a valid contract. We all are aware, as per the Asgard Contract Act 1872, a contract with minor stands void ab initio. Section 10 of Asgard Contract Act clearly states the essentials that are required for a valid contract. And one of the foremost essential is that the parties to the contract must be competent. Now, what the competency is also stated in Section 11 of the Asgard Contract Act. Section 11 of the Asgard Contract Act clearly states that every person is competent if he has attained the age of majority, he is of the sound mind, and he is not disqualified by law. Until and unless all the 3 conditions are satisfied, we cannot say it is a valid contract. And here, the respondent Loki is a 17-year-old minor. Therefore, he is not competent to contract. And if the conditions of the valid contract are not fulfilled, it stands that the contract is not a valid one. Also, Your Lordship, seeing the landmark judgments as given by the honorable courts, it has always been seen that the contract with a minor stands void ab initio, irrelevant whether the minor had the knowledge or he had fraudulently.
Wait, Miss Counsel. Now, do you want to say that that minor does not have email address?
No, Your Lordship, the minor did have email address.
Regular email address or minor's email address?
Your Lordship, a minor email address, since he did not turn 18 when he entered the contract.
How can you be so sure? Because in fact, it is not there. How he has even applied? He must have applied by using email. And that's why he may be impersonating his age or hiding his age.
Your Lordship, while making an email, it's not always asking about your age. Since it's about the hired-in platform, even in that hired-in platform, it's not always relevant that your age is always asked. The hired-in platform nowhere as stated in the facts that it always required a major to be competent enough to make a profile. It's just a social.
What is this with a very ancient case which you are citing, Mori Bibi? You don't have any latest judgment here.
Indeed, Your Lordship, the latest judgment even follow the judgment given in the Mori Bibi case. Since the
why should I trust you without any authority? You are not citing any authority.
Indeed, Your Lordship, the judgment given in it is still being followed and not being struck down. And even the Supreme Court still follows it. And the present case even follows the judgment given.
No, that is a statement which is not backed up by any recent case or recent authority. Why should we trust? Why should the court trust your argument?
Your Lordship, the case cited is still relevant and still being followed.
That you are repeating.
The council would like to plead ignorance here, Your Lordship.
No question from my side.
May I please proceed, Honorable Bench?
Yes, proceed.
Since the essentials of the valid contract, as stated in Section 10, has not been satisfied, it is clearly inferred that a contract between the Star Consultancy Services and Loki is not a valid contract, and hence the Honorable Court has always been of the opinion. If your court is satisfied with issue 1, the council would like to proceed with issue 2.
Yes, proceed with the issue 2.
Much obliged. Issue 2 deals whether there's any inadequacy done on behalf of the company. Your Lordship, if the company would have been diligent enough and working sincerely since the beginning, the precious time of this honorable court would not have been wasted. The clause that the offer letter should not and cannot be accepted by the minor is of so much relevance, then why did not the company mention the same in the advertisement? The advertisement given in the given by the company clearly states that they are looking
Why
for.
you are mentioning company, Loki? Why you not referring them as petitioner respondent? What is this?
Pardon your lordship. The petitioner gave the advertisement clearly stating that they are looking for the students and tech enthusiastic. Students here, lordship, is very vague. It's a very vague term. Students even include the school-going students, even the students pursuing their undergraduate degree, even the students who are pursuing their master's degree. Only the requirement that has been added by the company is that it must be a student and a tech enthusiastic, nothing more. Not clearly stating that they are looking for a student who is a major as well and even a tech enthusiastic.
Ms. Counsel, is there in terms and conditions in that advertisement that minor should not apply?
Not at all, your ladyship. That the advertisement given by the company nowhere stated that they aren't looking for a minor.
And in the contract itself, when the minor, when the respondent signed this contract, whether there was any terms and conditions for this thing that minor should not contract?
Indeed, your lordship, the company mentioned it in clause 27 out of the 35 clauses, and in the second last page, that is the page 7, has been the so relevant. Why did not the company highlighted this point, and why did not it clearly stated in the foregoing provisions? Like, why did it not clearly stated in the first page or in the first few provisions? The question that the company has came up with, that is called about the competency. If the company was so much conscious of what people they are going to employ and what they are looking for, then why did not the company mention it earlier?
So if the company has not mentioned it, so it's not an excuse that you will not see the terms and conditions. Whether it's on first page or it's on last page, it's the duty of the person who's contracting. He should read all in terms and conditions, then only he should sign. Right. So that means fault was there in the part of respondent also.
Indeed, your lordship, the fault was there on the part of the respondent as well. But your ladyship, if the company with such a huge manpower can commit this kind of negligence, then a minor can plead his infancy in this case as well.
Ms. Counsel, for construing negligence, there should be certain duty and omission to do that duty. And the first duty here is that of applicant to go through terms and conditions. And then only it can raise hand on the company, okay?
There is a rule in the council that one who is coming to the court should come with a clean hands. Right? So your hands is not clean here.
Indeed, your lordship. May I please proceed?
Proceed.
Your lordship.
Counsel, sorry. So you are accepting that there has been a mistake by you, by the respondent?
Indeed, your lordship. The respondent, in a hurry, without reading the terms and conditions as clearly stated in the facts, accepted the offer letter in the same way.
Okay, so we will not accept 5 lakh compensation. We will reduce it to 4 lakh compensation. That's fair enough. Since the respondent himself and you agree that there has been a lapse on his part, so therefore it's right that the compensation of maybe 4 lakh should be given.
Certainly not, your ladyship, since compensation will be granted by the honorable court if there has been a contract, if there has been a breach of the contract and also the fraud committed as stated by the company. Company filed the case on this account only, that if since the respondent has committed breach of contract and fraud, and 5 lakh rupees should be granted. But since the contract with a minor, your ladyship, stands void of issue, since there was no contract, there comes no question of breach of contract and fraud as well.
But you are accepting that there has been lapse on your part. Okay, carry on.
Much obliged, your ladyship. The council would like to state that there has been a sufficient time and the petitioner had enough chances. The company selected the applications and gave the email to the respondent on 17th October. Video conferencing interview was scheduled on 28th October, and the official hiring email to the respondent was sent on 7th November. The span of time clearly states that if the petitioner wanted and would have asked for the original documents to produce, they would have known that the respondent is not competent to contract. Also, your lordship, company clearly in its advertisement states that they are the world's third largest company and handles governmental software as well as the contractual software. If the company is of such a huge brand and reputed, and they almost enroll 15,000 1.5 lakh applicants. So if the company would diligently sit and check the documents, no matter the council would not even, the honorable bench don't even know how much minus the company would even would find. With this, if your lordship permits, the co-counsel would like to proceed with issue 3.
And what are the issues which your co-counsel would be dealing with?
Your lordship, co-counsel will deal with issue 3, whether there is whether the respondent has committed breach of contract and fraud.
So hand over.
Much obliged.
If your lordship permits, the co-counsel would like to begin with issue number 3, that is whether the respondent has committed breach of contract and fraud.
Define breach of contract. When contract is not even concluded here, where is the question of breach of contract?
Your lordship, the petitioners have raised this question, have not raised this question, but yet they have prayed in their request. They have requested in their prayer to hold the respondent liable for breach of contract and fraud. Hence, the respondent would like to answer.
This is not allowed. No, this is not a rebuttal round. You cannot point out the mistake of the opposite party. Okay? Prove your case. Prove your case. Technical error. Prove your case.
Your lordship, breach of contract occurs when a party to a contract fails to abide by the obligation that are mentioned in the contract. And here, Loki has not the respondent has completed his assigned task with due diligence and within time. Hence, there was no contract. There was no breach of contract occurred.
Ms. Counsel, you're saying there is no breach of contract. Tell me whether there was contract.
No, your ladyship. Since the contract with a minor stands void ab initio, there was no formation of contract in the first place.
Okay, so is there any agreement between these two parties?
No, your ladyship. The petitioners are trying to. The petitioners are trying to hold the respondent liable for breach of contract and asking for compensation of ₹5 lakh. And the respondent is trying to prove that there was no contract in the first place, and hence there was no breach of contract or fraud have occurred.
Okay, Ms. Counsel, if there was no any contract, on what basis you are doing the job and you are receiving the remunerations?
Pardon, your lordship?
On what basis you were doing the job in the company, and on what basis you are receiving the remunerations or payment from the company?
Your lordship, the respondent has given his due work and earned the money. He has earned the money with his work and providing services, and hence the remuneration was well deserved.
The remuneration was there with respect to the contract only, right? When contract was there, remuneration was there. If there was no contract, you have to revert back the remuneration. You have to send the remuneration back to the company.
No, your ladyship. The respondent has earned his new remuneration with his work, and it was well deserved. And
Under which legal capacity? That's what lordships are asking. Under which legal capacity he is rightful to earn remuneration? Because contract has been void ab initio. It is just now established.
Your Lordship, the right to work is
So was he a bonded labor? Under which was he a bonded labor or slave?
No, Your
Because
Lordship.
there was no agreement. So why he should get any remuneration? This is the point.
Your Lordship, neither the company nor the respondent knew that the respondent didn't know that he was not competent to enter. He was not competent to apply for the job, as well as the company did not know that the respondent was minor. The company only came to know that the respondent was minor when they have verified the documents after about 2 months of starting. That after about 2 months, the respondent has started his job.
So that company is asking for the and charging upon you for the fraud, because you have concealed the fact that you were the minor at the time of signing the contract. It means only you have willingness to take the benefits from the company, to take the remuneration from the company, to do the job and take the remuneration from the company. You have no any idea regarding the reputation of the company. Yes, you are doing the job in a very utmost care, but simultaneously you are creating the fraud. You are doing the fraud with the company to concealment of the facts that you were minor at the time of the signing of the contract. Okay.
May I, Your Lordship?
Yes.
Section 17 of the Asgard Contract Act states that it means and includes acts done by a party with an intention to deceive the other party. Here, the intention to deceive is an essential ingredient, and in this case, in the respondent's case, there was no active concealment of the fact that he was a minor, and even produced the original document when asked.
How you are able to establish the intention that the minor's intention was the bona fide or a mala fide?
Your Lordship, it is clearly stated. It is clearly stated on page 2 and line 4 that the respondent had accepted the offer letter without reading it throughout. And when asked for documents for verification, he had produced the original documents within the given time. Hence, it is proven that the respondent did not have any malified intentions, and he was merely excited to start a new job and provide some legal aid, some financial aid to his family.
Ms. Counsel, is it correctly that I am going to sign an agreement without reading it? Is it correctly?
Pardon, Your Lordship?
Is it a correct plea that I am going to sign an agreement, okay, without reading the agreement, without reading the terms and conditions of the agreement?
No, Your Lordship. It is important to read the terms and conditions. Or
yes, it means the minor itself on the point of the negligent regarding the terms and conditions of the company.
Indeed, Your Lordship.
You were so negligent regarding the terms and conditions.
Indeed, Your Lordship, there was negligence shown on the minor's part. However,
it means itself you are going to admit it. If you are admitting that minor is on the fault side. Okay.
Indeed, Your Lordship, there was fault on the minor side. However, it cannot. The company cannot ask for compensation or be provided compensation, because the minor cannot be liable even if he fraudulently shows himself to be a major and be asked to return the.
Your statements is itself contradicting to each other. You are saying if the minor is doing the act fraudulently, but he is not liable to pay the compensation.
Lordship, it is stated in the. Your Lordship, it is stated in the case of Sadiq Ali Khan versus Jay Kishore that it was observed by the Privy Council that an act committed by a minor is null and incapable of finding a plea in court. In this case, it was established that even if he fraudulently represents himself to be full of age, then also the contract stands void. In the light of this case, the counsels for the respondent plea, may I
I
start?
have a question for you. You have been altogether saying, that there has been no fraud, and there is nothing wrong that your client has done. But don't you think that, there has been some sort of misrepresentation which your client has committed, I would say. And also, I would like to know what's your take on the difference between fraud and misrepresentation, if at all there is any, counsel.
Indeed, Your Lordship, misrepresentation happens when we have no intention of fraudulently presenting ourselves other than what we are, or we believe ourselves to be, or something to be something else. Whereas fraud is committed intentionally, and here merely a misrepresentation has been done on the minor's part, and fraud has not been committed.
But this you have not stated anywhere in your submissions that there has been misrepresentation. Have you, or you haven't?
Your Lordship, there was no issue for misrepresentation stated in our memorial.
But you had to, point that specific thing out. If you are saying it in your arguments, then you must also write it in your submissions that there has been no fraud, and we agree that there has been some sort of misrepresentation. But you haven't written this anywhere, I suppose. Is that correct?
Your Lordship, I have merely answered your question and not argued that there was misrepresentation happening on the minor's part.
All right. Please proceed.
May I please proceed with the prayer? Honorable bench.
Yes, please proceed.
Wherefore, in the light of the facts stated, issues raised, and arguments advanced, and authorities cited, it is most humbly prayed that this honorable court may be pleased to adjudge and declare that the contract between the minor and the respondent and the petitioner is void ab initio, and to dismiss the claims that are put on the respondent, including the claim for compensation, and pass any other order, direction, or relief that it may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the counsels for the respondent forever humbly pray. If I may be of no further assistance to this court, the counsel.
Counsel, I would like to ask a question.
Yes, Your Lordship.
Okay, you have written that in your prayer to declare the contract between the petitioner and respondent as void ab initio. Okay.
Yes,
and
Your
to dismiss
Lordship.
the claims that are put on the respondent. It means
yes.
Itself in a prayer you are saying that the contract is void ab initio, so that at least you should return back the remuneration which you have received from the company.
Your Lordship, I have cited a case here of Sadiq Ali Khan versus Jay Kishore, where a void ab initio contract is null and void and unable to find a plea in court. And another case there has been where even if the minor has accepted monetary exchange in money in after fraudulently representing himself, he cannot be bound to return the money, since it would be stating the contract as valid.
Okay, is it mentioned anywhere in the Mori BB case?
No, Your Lordship.
Is it mentioned? It's mentioned. Okay.
Pardon, Your Lordship.
Proceed further.
May I raise the case now, Your Lordship?
Yes, proceed. Okay.
much grateful for the time and patience of this honorable bench.
Thank you so much, participants, for the wonderful argument. Now I request all the participants to please leave the meeting. I'm so sorry. I'm so sorry. If participants can start with the rebuttal and surrebuttal.
With the permission of your lordship, may I begin with the rebuttal?
Yes.
As speaker mentioned, as the respondent mentioned, that company has ample time to check the age of respondent. So there was no deadline mentioned to submit offer letter. So why the respondent submitted it hurriedly without reading it throughout? Isn't it negligence on the part of respondent?
You
Yes, ma'am.
continue your rebuttal. You don't ask other party to respond right now. They will have their time. You just finish your rebuttal points.
Okay, your lordship.
Finish it fast.
As the respondent accepted that company didn't know that he was a minor, was there not a duty to speak on the part of respondent about his age? Respondent committed fraud since there was active concealment of the part on the part of the Loki about his age, and there was no intention to deceive the party. And there was intention to deceive the party. Mere silence is not fraud, but respondent read the offer, which should have stated that there was duty to speak, but he intentionally deceived the petitioner. If the contract was void ab initio, as the respondent stated, then how they are stating that it resulted in breach of contract if the case was void ab initio? If they read the clauses, then if they read the clauses till 35 and extra 2, which is mentioned in Annex 2, then why did they read the clause that the offer letter should not be accepted by the minor?
Okay. Now this is the time of petitioner. Yes, your response.
Much obliged, your lordship. Answering to my learned opponent, to the first question that whether the minor did not read the terms and conditions. Okay, since the section 11 states that the person below the 18 years of age, a major cannot be competent to contract. Since a major cannot be competent to contract, but even in your memorandum, you are stating that the company is itself competent enough. So if one party was competent enough, you even on your part did not check the documents. You are issuing the offer letters, giving the company software just like that, without even asking for the documents. And when such a huge manpower, you have so many teams, you are hiring 1.5 lakh people every year. This is the way that the company with such a huge brand works, without even asking for the documents. When such a huge negligence is committed on the part of a company that handles so many software, even of the commercial as well as the governmental, then this negligence of a minor 17-year-old boy can be ignored. If the company of such a huge brand fails to work on its end. If your lordship permit, may I oppose the question?
Oh, done. I guess, yeah, technically this is done. You cannot speak any further. No parties can. Yes, moderator, further you can carry ahead.
Thank you so much, Your Lordship, and the participants. The participants, you may leave the meeting.
Oh, wait. We will give certain feedback here about both of the teams. So my personal feedback is that there is lack of research for both of the parties. Secondly, the demeanor has to be maintained. It has to be understood. Thirdly, when you are pointing out the resources, you are using newspaper articles which are not considered as an authority. So your authorities, what you are citing, they cannot be accepted. Apart from that, there is a lot of melodrama in your presentation. Your presentation as an oralist should be very polite and to the point. Apart from that, there should be no allegation or cross allegation. For your future reference, you can learn it. Apart from that, while you are submitting and you are presenting your issues, we all have found no sub-issues. When you are drafting issues, the issues are very lay for a layman. So you need to a bit complicate your issues, substantiate it. There was a lack of latest case laws. There was lack of any book references or any references related to dictionary or even the Bare Acts. So you need to do a comparative study also. So that would be my personal review. I will mute myself for other learned lordships to give their reviews.
Yes, sir. Saurabh sir, I agree with the view of the Saurabh sir, and those things I will not repeat. But the thing is that firstly, you should be aware that you are representing the petitioner or the plaintiff or the respondent or the defendant. So these are the very basic questions. So you should be aware about those things. Another thing is that sometimes about the coordination when you are presenting a case before the bench or before the district court or the Supreme Court. So there also you have to find out those relevant cases or those provisions which you have to say. The another thing, last thing upon which I will focus, and that is very important, that is about the issues and about the prayer. So you have to see that your issues, prayer, and the jurisdiction, these are very important things. And about those things, both the parties, you should be very clear. You should incorporate those evidence or those documentary evidence which can be produced before the honorable court. Rest is okay, and all the best to both the teams. Thank you.
Yes, guys, I would like to mention one thing that regarding team 15 moot proposition that you have mentioned the table of cases. Am I audible to you?
Yes, sir.
Yes,
You
sir.
are audible. You are very clear.
Yes. And in the moot proposition in the table of cases, you have mentioned case number 11. Uberoy Mohinder Singh and Associate versus, you have just scraped it, United India Insurance Company Limited versus RA Case Rex ... V Lakshmanan versus BR. It's a, okay. State of Rajasthan versus Associate Stone I ... SI ... It's not a proper manner to mention the table of cases, to mention the cases in the proposition. Okay. And just the thing which is mentioned by Saurabh Siddharth sir and Dr. Ashish Singhal sir, just focus upon that. Thank you.
Sir, you're not audible. Sharangi sir, you're not audible.
Yes, moderator, we can proceed.
Okay, it was a good attempt, and you all need to be trained more and get your facts clear, which court you are going, why you are approaching the court, and other things about mooting, as has been pointed out by my learned judges here. So it's a good effort by the first and second years, and of course there's a lot that can be improved on. So I would like to congratulate the participants here, but you need to work on the legal aspect and case laws. Over to you, moderator.
Sir, ma'am,
Surya
Sharangi
sir.
sir was saying something.
Monica ma'am, yes.
Sharangi sir? I think his mic is not working.
Sarangi sir.
So, my feedback to all the participants is you should know the basic legal terms, the basic difference between the legal terms, okay? And you should know the basic maxims if it's applicable to your case. Second is courtroom ethics. You should know what is the courtroom ethics, how to respond when judge is asking question. Third is you should know the jurisdiction. Jurisdiction should be correct because this is a court and you are coming to correct court or not. It depends on your jurisdiction. Your issues should be proper, and research is you lack somewhere in the research. You have to research more on that moot problem, And lastly, the moot problem. You should have a good command on your moot problem. When the judge is asking any question relating to your moot problem, you should not see to a paper. You should know everything. Moot problem is something you should read twice, thrice. The number of times it is inside your head. You have to memorize each and every word of your moot problem. Okay, you should not see. Although you can see the cases in your your file, but you should not see the moot problem because that is your case. Okay, so that's all from my part. If Surya sir and Shadangi sir want to say something.
Thank you, ma'am. So I think much has already been said by my learned co-judges, and they've already told you about what all you need to keep in mind from the next time onward. So this was, I think, your first attempt at mooting, and considering that fact, I would say that you've done a good job. Just one thing I would like to tell you that whenever you're citing cases or any precedents, so you should try to stick to the ones that are most relevant to the given set of facts that you're catering to. So it is not about adding more number of cases and that would probably make your case stronger. That is not how it works. So you should try and focus on the landmark cases and the cases that are the most relevant to the given set of facts, instead of adding cases just to make the proposition or just to make the memorial lengthier. So you can keep this thing in mind, and I think we'll be seeing a greater effort from your side from the next time onward. So all the best to both the teams. Thank you.
So Salangi sir, are you here? Okay, his mic is not working. So I guess we should continue.
Thank you so much, Your Lordship, and the participants. Participants, you may leave the meeting now, and judges, please stay back.
I've submitted my marks. I think I would be taking your kind leave.
Sir, just wait a minute. I'll contact the OC. Yes, Your Lordship, we have received your marks. Thank you so much.
Okay, I have also submitted my marks. Please share.
Yes, Your Ladyship. Thank you so much. We have received yours. Monica ma'am, we have received yours too.
Thank you, and well done to the court master and the moderators and the timekeeper.
Thank you so much, ma'am.
Thank you so much,
Thank
ma'am.
you.
Thank you.
Judges, after filling the form, please proceed towards the canteen for the refreshment.
I have also submitted the score sheet. Can you please check and let me know?
Yes, Your Lordship, just wait. Yes, Your Lordship, we have received. Thank you
Okay,
so
thank
much.
you. See you.
Abhishek sir, we have received yours too. Thank you so much.
Have you received my this? I have submitted. Have you received? Have you received?
Yes, yes, Your Lordship. We have received. Thank you so much. Please move towards the candidate. So, Shant sir, we have not received your marks. And sir, please move towards the candidate.